So, hi everyone, and welcome to this webinar organized by the Beverly Hills Bar Association, and in particular by the International Committee of the Beverly Hills Bar Association, that I'm glad and pleased to chair since a couple of years. I am a co-chair of the committee together with Carla Pareja, that I don't think can be here today because she's traveling. But I'm very proud about this international committee because we are very active. We can organize a lot of webinars. We are networking a lot, making a lot of referrals, and we are all going to meet in person soon, even if we have tried to meet in person also in December during a beautiful cooking class in Italy. Let me say a few words about Paul, because Paul, you are really the master of this webinar. I really appreciate your work. You are a great lawyer. You are a trademark intellectual property lawyer. You are in the industry since a very long time, so you have a great experience. You know that when I have some doubt about the US law, I just go to you because you are the best. And thank you again for organizing this fantastic webinar today with so many speakers coming from many jurisdictions all over the world. And let me say that this webinar comes in a moment in which maybe there is a lot of confusion about copyright and intellectual property as such. And I believe that putting a little bit of order is so much useful. So Paul, if you don't mind, you know that I'm very quick. We have a lot of speakers, so I will just leave you the lead of the panel. Thank you.
Thank you. Good morning. Good morning to some of you on the West Coast, but for everyone else, it's afternoon, evening, or even tomorrow. If you happen to be in Hong Kong. I want to also thank the Federal Bar Association Intellectual Property Law section for co-sponsoring this event also. So in the United States, we are used to the idea that copyright registration provides certain benefits to rights holders. Register early, you receive the bonus of being able to get statutory damages and attorney's fees in the litigation. Register within 5 years, you get certain presumptions that you'll have the facts stated in your copyright registration certificate are correct. And at least if the work is not a work of foreign origin, now you will not even be able to register, you're not even be able to file a lawsuit in the United States for copyright infringement until there is registration actually issued and not merely an application filed. So the United States has been a member of the Berne Convention for over 3 decades now. And one of the key aspects of the Berne Convention is no formalities. You can't have formalities if you're going to join the Berne Convention. So we have softened up the idea of registration in the United States, but we still have a registration system, and we haven't completely gotten rid of it. But I've always heard that none of this happens outside of the United States. There's no registration system outside of the United States, and that was kind of the folklore. But I started looking on the internet and I found out that doesn't seem like it's really true. So I decided maybe I could contact some of my colleagues abroad and see what they might have to say. And this might be an interesting program for the Beverly Hills Bar Association. So we have only 1 hour to discuss this with our representatives from a sampling of countries here. So we're going to do this in an interview style, and I'm just going to ask a few questions. And then if you have questions for the speakers, we welcome them. Please put it in the queue or Q&A, preferably in the Q&A section, and we'll respond probably at the end after we have our initial comments and discussion. So let's get started. Let's start out with France. I have often heard that the copyright law in France is it's really important in France, and it's intertwined with the French Revolution, so it has an important place in the French mindset. Richard, is that correct? Do you have any copyright registration or anything like that in France?
Okay, so the first French law on copyright is from 1791 during the French Revolution, and since that time there where and there is no copyright office or compulsory copyright registration, even if we do have for some kind of works, some registration which are either open by private companies, or you may force to register some rights, for instance, in the movies industry, but it's really on a case-by-case basis and only for some type of works, and it's not general.
So what happens if you have how do you find out who owns what rights, or don't you?
First, there is a presumption in the French law that the work is owned by the physical person who pretends to be the author. And when we do have a litigation, for instance, an infringement litigation, you cannot raise a defense saying you are not the owner of the work, of the copyright on the work. The only person who can pretend to intervene is the one who will claim to be the owner of the work. So therefore, this presumption is very important when it concerns physical person. When it concerns companies, you have some rules saying, for instance, that collective works are owned by, copyright on collective works is owned by the company. So therefore, the only problem may be if you have a work created by a single employee, and if there was nothing in its work contract. So it's not a perfect system, but from a practical point of view, it is very rare to have a dispute about the ownership of copyright. And finally, you have certain system of registration, as I mentioned, with the collective management authorities, such as the one existing in the music industry, the equivalent of ASCAP in the US, for instance. So therefore, we have various systems which allows us to find out who is the copyright owner. Now to finish, there is a situation where things may be difficult. If the copyright has been transferred, there is no way to accept in software when there are pledges or concerning when we speak about the movie industry, but otherwise there is no way to find out and to be sure if a copyright has been transferred or not. So that's the only, let's say, weak part. But once again, from a practical point of view, I've never seen a situation like that where we had discussion about the existence or the lack of existence of a transfer of copyright.
And just one more thing, you had mentioned something about a private registration system dealing with software.
Yes. Yeah, yes. There is a French company which was created 20 or so 25 years ago, or perhaps even earlier than that, which allows to register software in order to give a date to the date of creation of the software, and to allow to register the software as it is written at the time of registration, because as you all know, software changes, and one of the issue when you have a version change, another version, an issue which happens often is to find out what was the content of the software, of the coding of the software at the time of the first registration or at the first creation. And this company allows to have the possibility to register and to be able to give some evidence to the court later on when needed.
Thank you. Let's move on to Iris in Argentina.
Thank you, Paul.
So tell me a little bit. Do you have a copyright registration system in Argentina?
Yes, we do. We do have a copyright registration system, but the basic principle is that copyright arises by the creation of the work. Argentina is a member of the Berne Convention and of the Universal Copyright Convention, but still we have a local registration practice. All works are registered with the Copyright Office in Argentina. However, for instance, foreign works, if the foreign author proves that he has met with the registration requirements of the home country of where the work was published, it will be deemed protected in Argentina. And in general, when it comes to literary works, there is an obligation for this applies to local authors, to the editors of the work, who once the work has been published, has been disseminated, the editor has a 3-month term to register the work with the Copyright Office. Otherwise, economic rights will be suspended. This means that it will not be possible to enforce the work if you are pursuing an infringement, for instance. However, the local courts during the last years, and basically bear in mind that Argentina is a member of the Berne Convention, so no formalities apply, it has been sustained that registration is not a requisite for enforcing copyright. But so what's the benefit? So the benefit, basically, it's an issue of establishing certainty as to the date of creation, establishing a presumption regarding authorship, but also, and this particularly applies to foreign authors, it's a question of evidence and cost. It's much easier to rely on a local registration. You have the local certificate if you have to enforce your rights. Of course, as I said before, you can, and it's recognized under our law that a foreign author can still enforce the rights if it proves that it complied with all requirements in their at home. But still, you will have to go through all this evidence, collect the evidence showing that you have the copyright. And you have to remember that in Argentina, all foreign documents have to be translated into Spanish. And on top of that, you need notarization and legalization with apostille. So in short, I would say that the benefit of having a local registration, although not necessary to enforce your copyright, would be beneficial from I would say from an economic perspective, and it would certainly make things easier when it comes to submit proof of your copyright ownership.
Thank you, Iris. Let's move on to Marita in Barcelona, and I'm glad to see you here. You're on mute.
I'm not. Hello, can you hear me now?
Yes, yes.
Hello, happy to be here with you.
So, Marita, do you have a copyright office in Spain?
We do. It's called the Registro de la Propiedad Intelectual, and it offers the recordal of copyrighted works, but it's not mandatory. So basically, it's as the authorship of a work and the intellectual property associated with it is recognized through mere authorship, it's not mandatory to register your work in the Copyright Office. But it's very cheap to do so, and it does offer a prima facie evidence of authorship. And if you want to establish a right in rem over your intellectual property, you need to have the intellectual property registered. In addition, we have the legal deposit system, which jointly with the Copyright Office would, in a way, create a sister system a bit similar to yours, in that everything that is published in Spain is subject to legal deposit, and a sample of the work is deposited in the National Library. And that is something that publishers, printers, everybody must do, whether it is a magazine, a published work, and now digital works.
And if you assign rights in your work to someone else, is there a method of recording those transfers?
Yes, you can record assignments, you can record license, if you want to license your work rather than assign it. You can record those, and it's also useful to record when you have joint ownership, because there's co-authorship. So you can also record those cases.
Okay, thank you. Let's move over to Hong Kong and China. Anna May, what do you have to say about copyright registration in those two areas?
Hi, Paul. Thanks for having me on the call. Sure. Let's start off with China, because I guess first and foremost, you have to know Greater China area, despite it jurisdictionally being well, there's China, Hong Kong, Macau, and Taiwan. All of them actually are different IP jurisdictions, requiring different registrations, etc., independently. So for China, we are actually very similar a position to Argentina. We are a party to the Berne Convention, and so works are recognized upon creation globally. However, we have a recordal system. The advantages of doing the recordal is it gives you a prima facie right of authorship, and it's easily done. Also, it gives you ability to enforce. Well, it doesn't give you the ability to enforce, because you have the ability to enforce regardless because of Berne. However, it allows you to enforce more easily. In the courts, you would require, if you're relying on a foreign work, it would require you to submit a copy, well, all the evidence, etc., and it would require it to be translated, notarized, and legalized, because the evidence is coming from abroad. And that's generally very expensive, because courts in China requires translation to be done by official translators. And so if you have and the official translators is dependent on the city. So Beijing has its own official translators, Shanghai has its own official translators, etc. Notarization and legalization is typically also a costly and timely issue. So if you have one done in China, a copyright recorder, it's relatively inexpensive and it's easily done. It gives you a prima facie right. Another issue in China, the reason why you want a copyright recorder is because most of the time you wouldn't rely on court system, which takes a long time. You would rely on the administrative systems. And also, so the administrative systems, if you have a copyright recorder, that's easily enforced. The third reason why you'd like to do it is because actually most people who enforce foreign works in China actually do it over the e-commerce channels, which is where most of the counterfeiting and infringing works are sold. And that I'm talking about Taobao, Alibaba, and all of those type of sites, because e-commerce is strong very, very strong in China. And generally the way that it makes it to the West and the rest of the world is through those channels. Now, if you do a complaint on their online platforms, you need to have a right. And a copyright recorded in China would be very helpful towards enforcing those rights in China, especially on these channels. The great thing with Copyright Recorder is also because it's cross-class. So some of our clients, we would advise actually to do, in addition to their trademark application, a copyright report, even of trademarks. And if you do that, you would be able to have a more, because generally for trademarks, you only would file for the specific class you're interested in. But a copyright would grant you cross-class protection across all 45 classes. And that gives you a greater benefit of being able to enforce across generally classes you don't expect to be infringed upon, but in China it does. So that's the position on China. In Hong Kong, it's a completely separate legal system. And as such, we follow more the British system. We are also party to Berne, but there is no recorder system. The only, so you would have to go to court and prove your copyright, etc., both foreign and domestic. The only time when you would be asked to sort of register a copyright would be if there is a customs issue. So if there's infringing goods coming through the port in Hong Kong, customs would require you to do both a recordal of the copyright as well as a recordal system for the examiner of the copyright. So the right holder will need to appoint an examiner who has the ability to tell the difference between real and fake and infringing copyright. And through that, well, appointment of the examiner, you get your goods to be reviewed by customs, and also they would take the active steps of seizing the goods if there's infringement. So that's, I guess, the position between and the difference between the two.
Okay, thank you, Anna-May. Let's move to Mexico. John, you can. John has amazing accent here. He's actually an American lawyer that has lived in Mexico for quite some time now, and he's and just get off mute, John, and I'll ask you some questions. You're still muted.
Oh, all right. I'm unmuted.
Okay, go ahead.
Oh, all right. Thanks.
So is there copyright registration in Mexico?
Yes, there is. The authority in Mexico is INDAUTOR, INDAUTOR, which is an acronym for National Copyright Institute, essentially. And yes, there is a copyright register in Mexico, and Mexico is a member of the Berne Convention, so in theory, rights exist based on creation, not based on registration. That said, when you're litigating a copyright infringement action, it helps enormously if you have a registration to prove that you actually own the work. It's very difficult to enforce any kind of an unregistered right, whether that's copyright or trademark. It's not impossible. I've seen it done once, but you really want the registration either in Mexico or, and I think this has been true in some of the other countries that we've heard from before, a registration from the United States or another country will also work. They just basically want a piece of paper saying that you own this. It's easier to have the Mexican registration in the sense that if your registration is from the US, you'll have to have it translated, which isn't that big of a deal, but you may need to get the an apostilled copy of the US registration, which, you know, if you're trying to get infringing goods seized on short notice, that could be a problem. You know, because apostille is, you know, it can happen quickly, but it doesn't happen from one day to the next.
How long does it take to get a registration in Mexico?
Before COVID, it used to be possible to go up to the Copyright Office and go to the window and ask for expedited handling and walk away with a registration. Now, even now, in most cases, you're going to either have the application granted or denied in 2 weeks, and usually within a few days.
So what's this thing called a reserva?
Reserva de derechos. And this is, I don't know of any other country that has anything exactly like this. And there's this idea, you have this legal concept in Mexican copyright law called the Reserva de Derechos, and it covers things that would be outside the scope of copyright protection. So that would be literary titles, the names of artists or groups of artists, you know, the Rolling Stones, the Beatles, for example, real or assumed names, sometimes fictional characters, like, you know, Bugs Bunny, for example, could be a reserva, and in some cases advertising gimmicks, but by far the most common use is for characters and performing names.
And if I transfer some rights in copyright, is there some place to record that transfer? Is it copyright?
Yes, you can you register your copyright or your reservation of rights with Indautor. Indautor will you know, they will record licenses and assignments. They will record. They're also responsible for authorizing collective rights management agencies. So yeah, I mean, their functions are fairly similar to the U.S. Copyright Office. The main difference would be that there are certain types of infringement actions that must be litigated in front of Indautor, and those would be usually types of infringements that have to do with failure of attribution or misattribution of a work. Economic infringements generally get litigated. They get litigated before INPI, which is the agency that handles trademark infringements, trade dress cases, things of that sort.
Okay, thank you. Let's move on to let's stay in the Western Hemisphere here. Let's hear what happens in Canada. Michael, Canada seems to be a blend of both civil and common law, but that doesn't mean anything necessarily. You have got your own copyright system, correct?
Yeah, and in respect of copyright, we're really a blend of the US and the UK approaches. And sometimes, you know, we take the best from each, sometimes we pick the worst from each. So it really varies from one area of the law to another. Copyright, I'd say we're similar to the UK's now abandoned registration system, where registration is completely optional. Like most of the other presenters have told you, it does not give you any more legal rights in litigation. You can get statutory damages and legal fees with or without a registration, but it does create a series of presumptions. Again, a little bit like what you've been hearing from other places. In particular, if you register copyright, you have a presumption that the copyright exists and that it's owned by the person whose name is in the certificate, and that only the people listed in that certificate are the authors. And you can imagine that That may not sound like much, but in any kind of complex work like a movie or a video game or piece of software, where you can limit the universe of possible authors to only the people that you have identified, you've advanced your litigation interest enormously. And if you're ever involved in litigation, our courts have held that if there is a registration, you can't have discovery on ownership issues and chain of title unless the defendant has some sort of specific allegation to make, which from a practical standpoint in terms of controlling costs and keeping the case within manageable limits is incredibly valuable, because most defendants suspect you have something messed up in your chain of title, but if they don't have anything specific to allege, they get locked out of discovery on ownership issues completely. And so ownership ends up being settled effectively just by the registration certificate.
So if you have a registration certificate and you sell your rights in the copyright to another party, you record that transfer of ownership in the Copyright Office? What do you do?
Those are sort of considered separate transactions. Canada will let you register copyright. Sort of, it's like a point in time saying, I'm registering this work today, and on this date, I'm the owner, these are the authors, this is the work. And separately from registering ownership in the work, you can register a particular transfer. And registering a transfer, again, gives you access to a set of presumptions, but they're more limited. All that you get as a presumption is that the person's named as the assignee in the copyright registration of the transfer is the owner today. There's also a presumption, if you ever have competing assignments of the same work, there's a first to register rule, as long as that person didn't have actual notice of a prior transfer. So it can be helpful if you're worried about chain of title to register copyright or transfer in the copyright, depending on what situation you find yourself in.
Okay. Let's go to the UK now with Annabelle. Annabelle, what's the registration situation in the UK now?
Well, first and foremost, there is a copyright office in the UK, which is called the UK Intellectual Property Office, which role is, I'd say, more a sort of consultancy and research and analysis role on behalf of the UK government, since it is the official UK government body responsible for intellectual property rights, including copyright. The UK IPO doesn't hold a register of copyrights. And so therefore, unlike what is set out here in your wonderful book, which I perused before preparing my presentation to remind myself what the legal framework is in the US, forget registration of copyright in the UK, forget registration of transfers of copyright. It's not something that the UK IPO does. And I received an email from them yesterday just to double check, because I was a little concerned that basically there's absolutely no registration of copyright. So I just wanted to double check with them, and the UK IPO confirms that the Copyright Inquiry Service is only able to provide general advice and about regarding current copyright law. And it doesn't have any registration process in place and doesn't want to do so in the future. So, for example, a few interesting projects that the UK IPO has handled recently in relation to copyright are a consultation on AI, artificial intelligence, and intellectual property. So that was closed in October 2021. The UK IPO has also done a consultation last year and also this year on the UK streaming, the UK music streaming industry, and how copyright can be better and neighboring rights can be better monetized for all stakeholders in the UK. And today I just finished an article on writing an article about the basically the exhaustion of rights, included in copyright, since the United Kingdom has exited from the UK, from the European Union via Brexit. So these three examples are examples of consultation that the UK IPO has done on behalf of the UK government and which relate to copyrights.
So if I have, I see an infringement in the UK and I want to bring suit, there's nothing to register. Is that
correct?
Right.
However, sorry, you wanted to?
No, go ahead. Go ahead.
Correct. However, what we usually at our law firm Crefovi advise our clients to do is are two things. First is to ensure that they set out on their work, their creative work protected by copyright, the C in a little circle sign, as well as the name of the author and the year during which such work was produced. So as a protection with the little copyright symbol. Whether you mark the work or not doesn't affect the level of protection you have as far as copyright law in the UK is concerned, but at least it gives some warning to anyone who sees that that copyrighted work that you are the author of such work. And the other thing that we suggest our clients to do pre-litigation is to always keep the drawings, the drafts, the various versions of the scripts, all the material and tangible documents, materials that that can support the author in asserting his or her rights as the author of a work.
Okay, now I think you've all heard each other speak. Do you have any comments on any of the systems that that any of the other speakers have made in their country? Do you have any comparisons between what you do in your country versus what you have heard from our other speakers? Go ahead. Well, we'll start out with Michael. Go ahead.
Sure. I'm just curious how others in countries that don't require deposit of a copy of the work or an extract, how they correlate the work with the registration certificate, because that's always a problem in Canada. You're not required to submit a copy of what you're registering. And so you inevitably get, in some cases, get into a fight about how do you connect the work with the certificate, because other than the title, you often have no information to correlate the two. And I'm curious what best practices are in other countries on that point.
Not in our case, we do have to submit a copy. And in fact, what a copyright office does, you have to fill in a form and to get information into that form and to submit a physical sample of the work. If it's an ebook, for example, you can upload an electronic document, but otherwise you have to submit a physical sample of the work, and the Copyright Office, they compare that to make sure the information matches the work and vice versa. And when you file a contract, an assignment contract, which in our case, it's important to, all assignments have to be filed with the Copyright Office. The Copyright Office also goes into the content of the contract, particularly to make sure that moral rights are not transferred. This is quite a characteristic of our system. I mean, you can assign, an author can assign the rights on a copyright, except what we call the moral rights. So the author keeps the authority to, on any changes, modification to the title, to the content, to the ways of reproduction. So when you get a copyright assigned, there are certain things that the moral rights remain with the author, and the Copyright Office just specifically checks and verifies that moral rights are not assigned, because it's not possible to do it in our system.
But that's a very important concept that we in the United States often don't even think about And moral rights, we just have economic rights. There's no such thing as, or very little in the way of moral rights in the United States. And I'm wondering if anyone else here might want to pick up on and comment on that concept and how moral rights affects registration or doesn't have any effect on registration or whatever else you do in your country.
Well, I don't know that it really has an effect on registration as such, but definitely the distinction between moral and economic rights in Mexico is essentially what Iris has just described for Argentina. And I venture a guess that it's similar in Spain and France as well, because I think it's all originally derived from the French Civil Code. A point I'd like to make, and again, I think this is probably true of the other civil law jurisdictions that are represented here, is that even though copyright registration only creates a prima facie right, in other words, that the facts stated in the registration certificate are true, absent contrary evidence. The fact is that in Mexico, and again, I think this is probably true in other civil law countries, you get very little of what Americans call discovery. So once something is established prima facie through registration, it's very difficult to get behind the registration. It's very difficult to prove that whatever is stated in the registration is false. I mean, there are cases when that can happen, but it's not a situation where, you just think there's something about this registration that's just not right, and you're going to fish around until you find out. You can't do that. And so prima facie rights take on a much greater importance, I think, generally in civil law systems.
I would like to come back on Michael's question. First, I forgot to mention that in France, like in Spain, since 1500, there is an obligation to file a copy of the works of the books at the French National Library. It's not for a copyright ownership issue. It was just made in order to have a kind of archival system of the creation at the time, and it has been obviously continued until now. And now we registered magazine and other kind of digital work we find. But this system exists, and it's one way to prove the content of a work. Another possibility, as I mentioned, for software, if you file with this private company, you know the content of the software. If you are a member of an author society, you have to file the work you want to be protected by the author society. So therefore, you have a way to prove the content of the music, of the paroles, of a song, of the content of a book, and so on and so forth. It's not perfect, but there are, according to the type of work, we have several possibilities to prove the content of a work, which has, in a way, nothing to do with the ownership. It can be, it's obviously, it may be linked, but I was answering about the question, the specific question of Michael about the content of the work. So we have some ways to do it. And concerning moral right, which which was, yes, created in France, I will say that, yes, it cannot be transferred, but nevertheless, it is something which is in a way different from the issue of knowing what was done when and who is the owner of the work. And so you can live with moral right with or without a copyright office. I think that those are two different issues.
Annabelle, why don't you had some comment here?
Yeah, I do actually. It's more like a question. I've heard, of course, all what my co-speakers had to say about the registration processes in their respective countries, and I was actually surprised to hear that quite a lot of them do have a lot of registration requirements. And I'd like to just raise the sort of debate and also see from a perspective, from a business perspective, and also a creativity enhancement perspective. How do you reconcile the need to basically push innovation of your clients, of innovators in your own country, which with such stringent requirements or incentivization to record and to register every work protected by copyright that they make? Let me take an example. Nowadays, everybody's listening to podcasts on iTunes and on other podcast aggregator platforms. These podcast content creators or other content creators, these content creators make podcasts and put in the public domain content every other day. If they are professional content creators, how can you have a sustainable, for example, podcast content creation practice if you have to register with your local intellectual property office every podcast that you create every other day? So that's just an example. Thank you.
I can give an example. I mentioned before, I could think of one case since I've been in Mexico where we managed to enforce an unregistered copyright. And it wasn't for a podcast, it was actually for a clothing company, and it was like the logo that they put on their polo shirts. And we managed to get a copy. I don't remember exactly why, but we couldn't get a trademark registration.
That wasn't protected by trademark, the logo?
You know, I'm trying to remember the details of the case, and it should have been, but it wasn't. And so for some reason, we had to go with copyright. And we managed to convince IMPI that they couldn't require registration because of the Berne Convention, and we had a declaration from the graphic designer who actually created the work, and we established ownership that way. Now, if we tried that tomorrow, would it work? I have no idea, because there's no, as far as I know, there's no published jurisprudence on it. We just happen to have luck with that particular examiner on that particular day. And I would imagine that if you were talking about a podcast and, there's really no dispute about who's producing the podcast or who's speaking on it. I mean, maybe it would work, but I just don't know of a case in which it's come up.
Let me just mention some of these questions that have been put in the either in the chat or in the Q&A, and some of the speakers have already responded. And one is, in China, can a registered copyright be invoked as a basis for trademark oppositions to a logo mark? And Annabelle, you mentioned that you responded.
I can briefly respond to that. I think that's one that's asked in the panelists and the hosts. So the short answer is yes. That's actually a defensive filing strategy that we do propose to our clients, especially since trademark applications are harder to get in China, given that they are, opposed marks, and it takes a while to get rid of the many cited marks in China for any trademarks, given the large number of trademarks there are in China. So we do recommend people do a copyright, especially for device marks, but not so logos rather than word marks. Unfortunately, for word marks, they probably won't get through the originality threshold, and as such won't be able to be recorded with the copyright because there is, despite it being just a recorder system and not being, there's no substantive examination of copyrights that are recorded. There is some sort of a system of review with the Copyright Office, and they will reject those that have originality issues. So if your copyright recorder date is prior to that of the applied for mark date, the date of the application of the applied for mark, then you're right, and it's identical, then your copyright recorder will be good evidence to be used for the trademark position. So it is, unfortunately, many clients only apply for a copyright recorder or think about it at the point when they have a trademark position already active. And then that's a bit late. I mean, it's still helpful, but it's not as helpful as if you had applied for it early, right off the bat. And then you can use it against any class in a trademark opposition.
I got some, I heard some discussion about this, but any actual experience using a U.S. trademark, a U.S. copyright registration for an infringement litigation in your country to help show ownership?
Yes, actually we use a couple of times, we based litigation, actually trademark litigation, on the basis of a US copyright, on the existence of a US copyright. And it's pretty usual, I mean, particularly when it comes to the names or titles of movies or films that someone here tries to register as a trademark or similar or a similar character that is being registered as a trademark locally, then the opposition can be perfectly based on the existence of a US copyright or on the existence of a foreign copyright. And again, it doesn't need to be registered. As I said, I think initially, then when it comes to submit evidence, well, you will have to show that the owner has an existing copyright, and you have to prove it, but it doesn't need to be registered. And you can rely on copyright, on the existence of copyrights, just for trademark cases.
I advised a few years ago a Californian-based scriptwriter in relation to her dispute with a London-based film production company which had optioned her a script, a film script, and thankfully this Californian client had registered her a script with the US Copyright Office. So when it came to basically prove to the UK independent film production company that she was the sole author of this work on the script, and she had actually registered several drafts of a script with the US Copyright Office, that was quite useful and to build up her claims. So we use that for pre-litigation settlement attempts. And then unfortunately, the UK independent film company went bust, and then we had to stop there because there was nobody to negotiate with after they wound up.
Yeah, I would say that the US registration will work for Mexican copyright litigation without a great deal of difficulty. The only the only two things I would mention is that you would need to get it translated into English, and you will need to get it a certified and apostilled copy, which that's not impossible, but it can take a week to do or whatever. The other thing to remember, and this is sort of a tangent, in Mexico, if you're going to file if you're going to file a copyright, in many cases, you're going to need a full power of attorney, and powers of attorney, again, in some cases need to be notarized and legalized, and that doesn't happen from one day to the next either. And, you know, if the client is in an industry where they expect to be filing, you know, copyright infringement suits or going in front of customs and it makes sense to have a good firm in place and grant them a power of attorney so that you're not pulling your hair out every time you need to file a lawsuit.
Yeah, just to answer to your question, Paul, I mentioned that in the discussion area. I mean,
Richard, you're frozen. Michael, why don't you go on until Richard is back online? Oh, no, he's back. He's back. You're back. Okay.
So I was representing a Chinese company whose rights were infringed in China, and my client was selling in France, and another company was buying goods from the infringer in France. And one of the part of the discussion was one part of the defense was to say that the creation of the infringing goods happened before the creation of the original goods. And it was not a question of ownership, it was a question of that date of creation. And we were able to prove the date of creation because the Chinese company had filed with the US Copyright Office, and we had the documents from the US Copyright Office, which were taken into consideration by the French court as evidence of the date of creation of each one of the infringed goods.
So I have a similar story to share here. Our courts have generally taken the position that if you're suing about a Canadian copyright, you need to look to Canadian rules, Canadian registrations. But in very rare circumstances, they may use the US certificates, not so much as legal rules, but more evidence. And in one case, there were US certificates filed decades before the litigation. And the court looked at that and said, look, they clearly didn't file those in anticipation of this case. The fact that they filed them then suggests that they had a good faith belief of who the author was. It was a fight over who translated a work. And so in very rare circumstances, Canadian courts may look to foreign filing certificates, but essentially as evidence of a transaction rather than because they have independent effect. Normally, they're going to look to our own register and they're going to follow those rules.
Michael, would it be evidence, I guess what you're saying, it would be evidence that this work existed on this date, and we know that it existed on this date because a copy of it was deposited with the Copyright Office.
Yeah, it could also be just who was the author, in the sense that if someone's identified as the author in 1960 and there's a fight today, you'd say, well, they probably wouldn't have done that if it wasn't the case, you know, absent exceptional circumstances.
But it's not the registration being treated as legally valid per se, it's just evidence of certain facts.
Correct. And maybe just one tiny little wrinkle for everyone out there. If you're ever suing a Canadian defendant for infringement of copyright in multiple countries, our courts take the approach that each nation has its own copyright, and you have to prove your ownership of each of them according to local rules. So you prove your Canadian copyright under Canadian rules, your Mexican copyright under Mexican rules, your US copyright under US rules. So that even if you've got a Canadian defendant, you may want to think twice about whether you want to sue them for all of those sets of laws, just because you're taking on quite a burden for yourself. Can be done, but it's you now have to prove your chain of title in multiple different
ways. Anna May, did you have?
Yes. Sorry, the screen froze. Yeah, on China as well. I wanted to. We did a litigation recently on fashion designs. So the designs provided to us was copyright elsewhere, obviously. The issue is right. I think it's similar to Canada as well. To what Michael was saying, we would require evidence. The evidence of overseas foreign certificates and foreign registrations will be for, you know, the proof of creation and the date. But even then, China definitely relies on China rules and China evidence. And evidence in China needs to be objective and not, so we don't take any affirmations, affidavits, etc. All those evidence are not regarded as good evidence in China. So it's independent, objective evidence. And what I mean is, registrations with official authorities, contracts between different parties signed, instead of, Mr. David Chan saying that he created this on which date. So that would not be actually effective evidence in China. So foreign certificates are of some value in terms of for evidentiary reasons, but only that.
Well, I think we're at the 1 hour mark, and I want to thank all of you for joining us. You have provided a lot of very good information, very interesting discussion, and once again, I thank you all for participating.
Thank you, Paul.
Thank you, Paul.
Thank you, everyone.
Thank you all.
Thank you.
Bye.
Thank you.